Can we go one more to help? Oh, no, let's just go. Chair and tire. Just like you name it. Oh, okay. You name it. Yeah. That's fine. Hey, Jordan.
What's going on?
Yeah.
We're living our best life.
Yeah, exactly. Yeah, it'll all be over soon.
That's what you meant to say.
Yeah.
Oh my goodness.
is where the lecture thing is, right?
Yeah, I'm pretty sure it is.
The front is not.
Otherwise, I'd be sitting in here for 45 minutes too long.
It's like everybody came to that first one and then decided not to.
Charlie was on her writing.
She didn't even look up.
She did. She was like,
literally in
I
my
hate you.
She didn't even look up.
I'm just sitting in class until other people taking off the choice is beneficial because you're gonna have to sit and sit in class with people taking off the choice. And you can't do that. Muscle memory.
Everywhere down that stand wrong.
Well, you know, you're learn how to be right-handed now. Oh my, just kidding. Nice. I brought my notebook. Maybe I'll take it.
We should have been able to pass foundation. But it's like the same thing, right? But it's, I mean, I got the heat. I got 66%. All my GPA changes that I had. So I only have like 3 actions. I'm actually appreciating it a little bit now because every day is not familiar. But we only did evidence with property scores and contracts, so you don't have to think about it. There's a lot. It is. If you're only studying for the bar, it's fine. But if you have 4 other classes or 3 other classes and a job, it's a lot.
So they'll say like,
Hours. Yeah, we did. It absolutely is not.
I'm like, it is not that hot.
I've never had it for contracts, but
Yeah. What?
No, that's why I stopped.
yeah, that's me too. Yeah.
I'm going to try to fix it. I'm going to try to call
Meanwhile, I'm
somebody
wearing a
to fix
sweatshirt.
it.
Yeah.
Y'all might be in quarantine or maybe me, I don't know. One of us must be ill. It's either hot in here or freezing.
I think it's very comfortable.
What's happening?
That doesn't feel good.
Here's what I feel like. It feels like
I could not see it all. Probably, yeah. It was like tight. And you know when I can't see, my mind drifts and I don't pay attention. Very green. It's fine, we didn't have to do that. It's fine. Yeah, so Thursday and Friday were both lined up for me.
Anyways, I've been like studying a lot and it's just really long.
No, it's at the library. I find myself like drifting. There's other people like studying for bar there too. I've been like okay. And Notre Dame. Well, like I see people watching the Barbary videos and I'm like, hey. Right? And then they look at they're like, like deer in the headlights. And I'm like,
It's a real thing and it really does happen. You you're deluding yourself. That was a good idea.
My worst nightmare. Like Brandy thought it was a nightmare. It's not a nightmare to you. And then they're like, I was like Barbie on the field.
I don't think it'd be good to like raise my hand and answer He's doing good. Dixie in the light.
So cute. I need the pictures. You have Snapchat?
She legit had a rabbit.
I can see your pictures of him.
I posted a lot about it.
She had it in her mouth.
I figure out what it is.
I was legitimately screaming.
Did she let everybody go? So I don't have to.
Eventually, when I smacked her, she had it in her mouth.
Everybody.
Greg called the whole thing.
Funny encounters. Greg's like, I'm Barbara. I can't be bothered. That's my camping.
It ran away. And Nick was like wagging her tail, and the bunny is screaming, and I was like, oh. And those things scream. Hopefully there are no bunnies at the end, right?
He's outside hanging out right now. Trying to protect the wet when hanging out.
Your brother.
Not kids yet, but I guess coming eventually. Who knows?
You don't like.
I like her better now, but you know. Good, and I feel like he's more like a casino. Yeah, so he's a classy guy. Not like his mom. Yeah, I don't know where to go. I would just She tried. Talk's not working.
I saw that.
Give me my dollar.
Corey, are you okay? She probably hit traffic. You know what happens when it rains at 75 and she's like, no go. People don't have I don't know what it means. It is hot. Whenever I turn, it's getting bigger and bigger. I'm like, why is this building so hot? It was hot outside. I'm walking muggy. Yeah, it feels like really humid here. Yeah. It's not that it's like hot, it's just humid. Like, what's going on? It's me. Big kid. Yeah. Like, rainy. There she is.
I'm just so hungry that my
Yeah, think about it.
Yeah, I don't.
I know, that'd be great. Now my
kind of a like I'm reading the news and like there was stories that I didn't know.
Yeah. We're like, I mean, now that you know,
So you don't make yourself, because it's like a habit. Well, what happens is like I'll see a funny video, and then like I'm 10 videos in,
oh yeah, I was too. I was on Instagram and I was like,
Speaking of my YouTube.
I was like, no. You know, lay back like, and I was like, it's better.
I deleted. No, I met someone doing. I got someone together literally. So I've been doing that. And it's like very so I can have my list of your bugs. Yeah. I bought Bar Max, I bought Bar Max, so I kind of understand. It kind of directed me in a guided way, so I was kind of just running around, like, I'm not going to read an outline, just, that's the only thing. I do better if I'm really listening.
Bar Max had lectures.
Yeah. I did, like, the MBE one, it's just the main subject, but I figured I can study out mine with the essay stuff, because, our 2 MPTs and an essay, and that's every morning. My weakness is MPTs and MBE, so. That's the one I did. I did the one with lectures though, so I can have.
Alright, good morning, guys. It's another Saturday morning that you get to spend here with me. But today we have Professor Bolts, who is going to do our contracts workshop. So I want everybody to thank her. Give her a round of applause for taking time out of her Saturday. This will be just like last Saturday, the first hour. Professor Bolts is going to give a lecture on contracts. We're going to do multiple choice questions for an hour, and then Professor Bolts will review those questions with you for the final hour that we are here. I will order pizza again today. Does anybody have any food allergies that I should know about?
Alrighty, how we doing? So how many of you have already started your bar preparation, reviewing materials? That's good. Okay. So a couple of things I wanted to talk about, particularly with regard to contracts and dealing with multiple choice questions. There is just no replacement for just knowing the law. Going through, because I've been through a lot of MBE questions, and some of the nuances in the way in which the questions are presented to you require a very clear understanding of what the rules are. You do not have much of an opportunity to almost know what the law is, right? So I can't recommend that enough in terms of just reviewing, coming up with a strategy for how you're going to memorize all of these rules. And so the first topic I have here is how are we preparing for it? I've taken 2 different bar exams in 2 different legal systems. So to some extent, I want to give you some benefit of my experience of walking into a jurisdiction and preparing for a bar exam. Yes, I know you have your materials, but I also want you to prepare yourself in making this information your own. To some extent, you may have to reorganize it a little bit, right? Particularly for contracts. If you're trying to memorize rules, reorganize it in terms of contract creation, contract defenses, contract performance and breach problems, contract remedies, right? Reorganize the rules in a way that you can memorize it so that when you're coming to a question and you see where the fact pattern is going, that'll help you
focus your mind on the set of rules that may be in play, okay? So you could do that with a lot of different topics. I used to do that for criminal law, particularly where you had major crimes and a lot of lesser included crimes. I would reorganize my entire outline in a reverse pyramid way so that the most inclusive was at the top, and then I would filter my way down to the least inclusive, and I would memorize all of the criminal laws in that particular way. So I want to encourage you to do that, particularly in the contracts area. Second, I want to deal with any gaps in understanding. I know all of you have had different contracts professors. And so in the way in which different contracts professors have approached the topic may vary in terms of what rules they focus on and which rules they do not. So I want you to take a few moments while we think about this and tell me if there's any particular gaps in your understanding of contract law that you particularly want me to review today. Typically, I've had questions about the parole evidence rule or 2207 or warranties. Can you go through that again? Conditions, what the heck are those? I don't remember conditions. Third-party beneficiaries, whatever. Okay?
I don't know what conditions are.
Conditions, okay. Thank you. Anyone else?
Community buyer and seller risk of loss.
2207. I hear that a lot. Anyone else? Okay. And does that include assignment and delegation?
Okay, on assignment and delegation, I don't know why I can't get those nuances with third-party beneficiaries.
Can it include assignment and delegation?
Yeah. Thank you for saying that. Because obviously I cannot teach a 6-hour contract class in 1 hour, right? So I need to focus, I really want to focus on what you need to know. Like what are you just not feeling confident about? So thank you for that. What else?
Parole evidence rule.
Okay.
That's what I was going to say too.
Oh, okay. Anyone else? I'm sorry? I can speak to warranties real quickly, yes. Anything else? Nice job. Okay. There are going to be times, I will say, if you still have your contracts outlines, I have noticed in some MBE questions, they literally fashion it out of a case. I read a problem and I was like, oh, that's that case, right? And that quickly drove me to the answer. So if you have your ability to look over some of your own case briefs from contracts, you still have them, or your outline that included some description of cases and the rationale, that can be useful as well, just for review, okay? All right, so let's talk about a couple of things here that you've identified. And if you think of something else, let me know. Because that's where I really want to spend most of my time on. I'm just going to say a quick statement about this. Reading with precision, particularly with MBE questions, I have noticed where a single word or phrasing in the problem can redirect the analysis. Anything in terms of must versus may, or what was the other one? If, but, or unless, right? Those are the kinds of terms within a fact pattern or sometimes within the 4 options that you're given to you that can shift the way in which you're thinking about the answer, okay? So I can't recommend this enough. Read with precision. Even as you're reading quickly, right? When you go through the fact pattern, when you go through, look at your 4 options, right? Because I know you all have been instructed to look at the options, then look at the fact pattern, and then, figure out what your options are. Look for those key connectors, right? Those key language signals that are going to give you some guidance as to how you should be approaching that particular fact pattern, okay? Let them be your key terms. All right, so let's go back to the gaps of understanding. And I'm going to start off with the easiest of these, which is the issue of parole evidence rule, okay? So parole evidence rule is always about bringing extrinsic evidence in to interpret a contract, right? You only have 3 things that you're trying to accomplish in the problem. 1, you're trying to introduce extrinsic evidence to directly contradict the plain language of the document. 2nd, you're trying to introduce extrinsic evidence to modify or supplement the language of the contract where that term, that language, that issue is not addressed. And then 3rd, you're trying to introduce extrinsic evidence to explain a particular ambiguity within the contract. Think of the frugaliment case with the chicken, right? What's a chicken? What's a hen? That kind of thing. So if you know that if that's the construct, what someone is trying to do, contradict, add, or explain, then the issue you have to go to next is integration, okay? Now, you may see what's called a merger clause. A merger clause is basically where the parties have said any representation, any agreements that we've made outside of this contract have already been included, and we're not planning to include anything else, okay? If you see that merger clause, then that tends to tell you you've got a totally integrated document, okay? Totally integrated documents are your promised land. That means that you cannot introduce extrinsic evidence to contradict, and you cannot introduce extrinsic evidence to add, modify, okay? The only thing you will be able to do is introduce extrinsic evidence to explain, but then you have to establish you have an ambiguity first, okay? Anything less than total integration, meaning that the document is not final and complete, is partially integrated. If it's partially integrated, you cannot introduce extrinsic evidence to contradict. Why? Because partially integrated documents are final. Okay? So you cannot introduce extrinsic evidence to contradict. You could introduce extrinsic evidence to modify, add to the contract, but, big but, only if that modification, that addition, that supplemental issue is consistent with the intent of the parties. Okay? And this is where people tend to get confused with parole evidence rule. Because when I'm talking about is it consistent with the intent of the parties and figuring out the intent of the parties, it starts to look as if I am just dealing with explaining the contract or identifying an ambiguity in the contract. The way in which sometimes this is presented can be a little confusing at that point, okay? But think of it this way. There is an order of operation, okay? You remember this from math, right? There's an order of operation. So when you're trying to figure out the intent of the parties, the first place to look is the contract itself, okay? The contract has to tell me what the intent of the parties is. If the contract doesn't tell me what the intent of the parties is, then, because I have a partially integrated document, right, I can introduce extrinsic evidence to add or modify. I can introduce evidence of the intent of the parties. I can ask the parties. Now, that's not my first go-to, right? I'm looking at the contract first to see what the intent of the parties is. I can ask the parties, what was your intent? Okay? Once I establish the intent of the parties, then I am comparing my extrinsic evidence that seeks to add or modify the contract against the intent of the parties, that I've now figured out what that is. If the term that I'm trying to add, modify, or supplement is consistent with what I've identified as the intent of the parties, and I have a partially integrated document, then I can make the argument for introducing it. Okay? If my modification supplement is not consistent with what I've identified as the intent of the parties, then I'm going to fight against it. Does that make sense? Okay? And then the last stage, which is not dependent upon the level of integration, right, is the explanation. But you have to identify an ambiguity within the language. So I mentioned that frugaliment case, which is usually the one that people remember. Okay? It's about the chicken. Okay? What is a chicken? The contract itself didn't necessarily define chicken. Okay? So they wanted to figure out, how do we figure out what chicken meant? Chicken, as the parties were arguing about, they were talking about two different types of chicken, sorry about that. Coffee's not entirely kicked in. Two different types of chicken. One was broiling, one was stewing. Okay? So what does that tell me? An ambiguity is a term that is subject to more than one interpretation. I'm still talking about chickens, but one party says one type of chicken, another party says a different type of chicken. So that tells me the chicken is subject to more than one interpretation. Okay? So now we have to figure out whose interpretation is correct. Where do I start? Just as I did before with the intent of the parties, I start with the contract. Does the contract define these terms? Answer, no. Does the contract give me a clue as to how I should interpret it? Okay? And in that particular contract, you had two choices. I could go to Webster's Dictionary and go look up chicken. Right? But the contract itself made reference to USDA regulations. How did it do that? Because it said the chickens had to be U.S. grade, I forget what grade it was, grade A, whatever. Okay? So that tended to suggest that the parties that would be consistent with their intent is using USDA regulations to help set the scope for interpretation, as opposed to Webster's. Right? Because the contract gave me the guide as to how far beyond the contract I should go to draw in my interpretation. Does this make sense? Okay? So again, I'm starting with that contract, right? The contract either has to define the term, or the contract is giving me some clue as to how far beyond the contract I should go to bring in other evidence of an interpretation to understand what the parties were thinking about at the time. Okay? Is this helpful? And then at that time, we figured out, the USDA had different types of determination as to size and everything else, as to what types of chicken we were dealing with. Okay? Does that make sense? Did that clear up parole evidence rule? All right. So, when are you likely to find parole evidence rule problems come up? Well, it's always in the case of where I have a contract and there is some agreement that was left out. Or I have a contract where all the terms were not defined. Those are my signals for when parole evidence rule is going to come up. Okay? Now, any other questions about parole evidence rule? Yeah.
The first thing that you had said was it can be introduced to contradict.
Mm-hmm. It cannot be introduced to contradict.
Not ever.
No. If you find that the contract is final, okay, meaning either partially integrated, final but not complete, totally integrated, final and complete, you can never introduce extrinsic evidence to contradict. Okay?
If a term in a contract is not material, can you bring in parole evidence to define it?
Not material?
Yeah. Just if a party asks to define it.
I'm not sure why. I'm not sure.
I just didn't know if that was something that would come up in a question. As like a trick answer, I guess.
That's a good question. I don't think they would use the term material, though, because I think material is probably going to send you off in two different directions, away from parole evidence rule, right? I think what they're, although, let me track that. I have seen one example where they threw in the parole evidence rule as an option, and it was a ridiculous answer to select, because the problem had nothing to do with the purpose of the parole evidence rule. So they are in some way testing your understanding of the parole evidence rule and requiring you to recognize that that doesn't make any sense. Does that make sense? Like, why would we be dealing with the parole evidence rule here? So they're testing your knowledge of the rule. Okay?
And with parole evidence, is it only the initial agreement? So like if you have a fact pattern that has, you have an agreement and then you're modifying it after the fact, does it just go with the original agreement?
No, I mean, you can go to a modified agreement, any sort of agreement that is final.
Okay.
Right.
So it's at the point where you determine that it's final, that's when you can bring the parole evidence, but you can't bring it for like negotiations or anything like that.
Before I actually have a contract, no. No, we, contract, you remember the parole evidence rule is designed to be a filter, right? Once I have a final or final and complete document, it's designed to filter out any extrinsic evidence that occurred before or contemporaneous with the creation of the contract. So think of it that way. It's kind of like once I get that final contract, I get to filter out all the other nonsense. Okay? Good question. All right, I'm going to move on then. Let's see. The next easiest thing to deal with are the conditions. So, I've got a contract. I've got two parties to the contract, right? So what you're looking for in the fact pattern is an event not certain to occur but which must occur for the underlying obligation to arise. What is that? The definition of a condition. Okay? That's my example of you just got to know the rule. Okay? You got to know the definition. What is a condition? Right? So if I'm reading a fact, yeah. Yes. It's an event not certain to occur, but which must occur for the underlying obligation to arise. Okay? And that's in the restatement, if you still have your restatements available to you. Okay? If not, you can look them up online. Okay. So, but that definition is correct, but not complete. Because that definition, an event not certain to occur but which must occur before the obligation arises, is really focused on what's called a condition precedent. Right? What is a condition precedent? It's a condition which must occur before the underlying obligation arises. Okay? So, if you had my class, I like to use the snow. A promises to shovel the driveway if it snows. If it never snows, it's the event not certain to occur, but which must occur for the underlying obligation of shoveling the driveway to arise. If it never occurs, then the underlying obligation never arises. Okay? But I could also have a condition concurrent. I can also have a condition subsequent. Okay? I could have a condition that cuts off this performance. I agree to cut your grass unless it rains. So I have an existing obligation to cut the grass. That obligation to cut the grass is cut off by the happening of an event not certain to occur. But if it occurs, cuts off the obligation to perform. Okay, does that make sense? I can also have concurrent conditions, right? So A and B, they both have conditions on their performance. The conditions are concurrent, meaning that both parties have to be ready to perform, which is also referred to in some of the materials as both parties have to be ready to tender their performance. Okay? So, try to throw in a fact pattern here that sort of talks about that. So essentially, I could be looking at let's say this is a contractor and a homeowner, A and B, okay? Contractor has to be ready to perform when the initial payment is made by B, okay? So they have to be ready to perform when the condition gets satisfied, homeowner's ready to perform, then contractor's performance arises, okay? B, my homeowner, has to pay the full amount of the contract to contractor when A finishes performance, okay? Homeowner has to be ready to pay, but homeowner doesn't have to pay until the contractor completes their performance, okay? Those are sort of an example of concurrent conditions. Now, how do you know what type of condition you're dealing with? The language has to tell you. Okay? And this is where I go to my third point, read with precision. If they're going to put a contract in there, a condition in there, they have to tell you, signal to you that there is a condition. If, unless, subject to, right? You're looking to something that tells me there is a condition in the fact pattern. Okay? And how they express the condition should tell you order. Okay? Now, just like a computer, there are default settings. The default setting is concurrent. Everybody has to be ready to perform when the other party finishes or performs however they're supposed to. Okay? The deviation from that is in the language itself. So if the language of the contract, the language of the story says something has to happen before somebody does something, that's a condition preceding. If they tell you someone has to perform until something happens, that's a condition subsequent. Okay? Is that helpful? So you really are looking for those language clues within the problem to tell me what type of contract I'm dealing with. Okay? Now, here's where you might get confused with your evidence study, or civil procedure study, I'm sorry. I believe it's Rule 9 of the Rules of Civil Procedure argue that a complaint has to identify conditions precedent with particularity in a complaint, and has to state whether those conditions precedent have been satisfied or have failed. You have to plead them with particularity. Okay? That's the crossover issue. What are they saying? If we're dealing with somebody has breached the contract or failed to perform, and there's a condition in play, you have to tell somebody what happened with the condition. Did the condition happen? Did it not happen? Or was it waived? Okay? So if somebody said they know the condition has failed, but they said they'll do it anyway, they'll still perform. Yes, I know it's raining, but your car still needs to be cleaned. I will go ahead and wash the car. That's a waiver of a condition. Because they know they don't have to wash your car if it's raining. But they're saying, I'm going to continue to wash your car, despite the rain. they've waived the condition. Does that make sense? So again, start with your definition. A condition, an event not certain to occur, but which must occur before the underlying obligation arises. Okay? Which goes back to my first point, know the rules. Okay? Any other questions about conditions? So far so good? How are we doing? Next thing I want to talk about that, let's see, again, pretty simple issue, buyer and seller risk of loss, okay? Because some of the contracts, well, the MBE certainly also includes a lot of sales issues as well. Buyers and sellers remedies, warranties, offer and acceptance issues with regard to the UCC as opposed to common law are subject for subject to being tested. Okay. So let's talk about the risk of loss issue. What determines risk of loss is the delivery term of the contract. Okay. Occasionally you'll see this. I haven't seen it most recently, but I'm not going to say it's not going to be there. But they will include an FOB term, free on board. What you're looking for is the place, right? The fact pattern has to tell you where the seller is and where the buyer is by their location. Why? Because risk of loss, FOB, is determined by that second piece of information. Okay? If it's an FOB seller's location, then it's an FOB shipment. And the risk of loss shifts to the buyer when the seller places the goods with the carrier and notifies the buyer that the goods have been so placed. An FOB destination, the seller still has to place the goods with the carrier and negotiate the contract for that transport. But the risk of loss does not shift until the goods actually arrive at their destination. Okay? So you're looking for those two pieces of information. Not just the FOB delivery term, but also the location of either buyer or seller. Okay? And to review that, feel free to take a look at 2319, 2503, 2504, 2508 of the UCC. Okay? And again, if you didn't keep your code book, Cornell Legal Institute has a website where the entire UCC is there. So you can go to that website and you can pull up any of these provisions. Okay, you need to review them. What else do I want to say? I think I already said, but if not, I'll say it again. If it's silent, if it just says FOB and nothing, then the default is an FOB shipment. It's a shipment contract. Okay? Seller has to put the goods with the carrier, notify the buyer that the goods are available for them, and then at that point, the risk of loss shifts. Okay?
When you say the goods are available, are they still being shipped on the way, or are they actually able for buyer to pick up?
It depends. Because in some instances, like let's say Walmart, right? You order something from Walmart to pick it up at seller's location, right? They're not shipping it to you, okay? So as soon as they tell you that the shipment is available, the risk of loss now shifts to you because it's an FOB shipment, but it's at their location.
So if they get robbed, it's on you.
It could be, yeah. Right? Now, hopefully, we'll get more facts to associate with that, right? There's other provisions related to destruction or loss of the property. There's, all sorts of other issues, right, that could change that risk of loss dynamic, because the seller is supposed to keep the goods available for the buyer to pick up. Okay? So the only thing that I think that might confuse people is the issue of tender and the issue of the buyer's opportunity to inspect. Okay? That's the one thing that might cause a little bit confusion with FOB, because even though I have an FOB destination contract, right? What is that? Seller has to negotiate the contract for the shipment, has to put the goods in the possession of the carrier. The goods have to reach the buyer where the risk of loss shifts. Okay? At that point, you still have to deal with the tender rules and the manner of delivery. Okay? So 2601, 2602, and the issue of acceptance. So the goods have to arrive in a time, place, and manner that enable the buyer to take delivery. Okay? If the buyer's offices closed at 6 o'clock and the seller arrives with the goods, the carrier arrives with the goods at 7, then the seller is responsible to keep those goods safe until buyer can receive them, right? They can't just park them on the street and say, hope it works out for you. Okay? In some instances, the buyer is required to have a secured place for the seller to deliver those goods. Okay? And so I know if you were in my class, we talked about the issue of terminal markets and other sorts of things. Honestly, I haven't seen terminal markets and those sorts of things dealt with in MBE questions, okay? But this is just to complete your understanding of this topic, okay? So if buyer has provided a location, like a terminal market, and says seller has to deliver and deposit the good at this location so it can be secured, seller has to do that, right? Buyer has to provide that. Okay, but if buyer doesn't have that, then it's seller's responsibility to protect those goods until buyer can act upon them. Okay, terminal markets in reality work that way because they are secure locations. They're open 24/7. So whenever the goods arrive, they get within the gate of the terminal market, and the terminal market secures it until the buyers return in the morning, and then they can inspect the goods. Okay, does that make sense? Warranties. Okay. So in Article 2, particularly, right, you have what can be express warranties. Okay. Seller makes certain representations about the goods. Okay. If there is a deviation from the express warranty, you have a breach of contract. Okay. But there are also implied warranties. Now, the most common one is the implied warranty of merchantability. Okay. Implied warranty of merchantability is in the UCC. I'm sure you don't want me to read it to you because it's kind of long. But what I will say is that generally what is said is that it is fitness for an ordinary purpose. Okay. There are other restrictions, other issues related, like it's 2-314. So if we're dealing with fungible goods, fair average quality, so I've used an example of like a grain silo full of rice. Okay, every kernel of rice doesn't have a UPC code on it. Okay, so how we determine its compliance with the implied warranty for merchantability is at the fair average quality of all of that rice. Okay, does that make sense? You could have think of a run, so I'm thinking of fabric, okay, like a bolt of fabric. Y'all know what I'm talking about there, right? So the run, okay, might have some variation in it, but the issue is that variation something that is normal to that thing, right? Would you have a streak running through it? Would you have a thread? What is your expectation with regard to that run? Does that make sense? And so we're looking at what is the ordinary expectation with that thing that is produced in a run. We're also looking at adequately contained, packaged, or labeled. Okay, so if everything is appropriately packaged and labeled as the agreement calls for, okay. So if I'm ordering 10 Samsung for, what are we up to now, 4G, 5G, whatever, ultra curve TVs, right, then every package needs to be appropriately labeled for the thing that I am purchasing. Does that make sense? Okay, and then the other thing that I've talked about only for, for purpose of illustration is sample. Okay, I told you that Target Tale of Woe story from many years ago of ordering the Extreme Sportswear T-shirts, and the delivery of the T-shirts that they received was not in compliance with the sample. Okay. That's a breach of the implied warranty of marketability because the sample sets the standard, right? So compliance with the ordinary expectations with regard to those goods. And so you're looking at the deviation associated with that. Does that make sense? Okay. So, one of your issues typically comes up with the implied warranty of marketability, which is applicable to everything, is whether or not it has been disclaimed. Okay. Because you'll find in a fact pattern, for example, a clause in there that says that the seller disclaims all warranties, implied, express, blah, 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 blah. Okay? Well, here's the limitation to it. If you're going to attempt to exclude or modify a warranty under 2316, particularly the implied warranty of merchantability, you have to mention it in writing in a way that is conspicuous. Okay? So what does that mean? If it says, I disclaim all warranties express, implied, or whatever, but it doesn't actually say, I am disclaiming the implied warranty of merchantability, then you still apply the implied warranty of merchantability, okay? Does that make sense? Because it applies to everything. And so if you're going to disclaim it, you have to call a thing, okay? You have to say it with express, conspicuous language. And 2316 subsection 2 specifically says, with regard to the implied warranty of merchantability, okay? So I have seen that on a couple of MBE exams, is that they will have, some incident that occurs with regard to the goods. They'll have this generic sentence in the contract, and then they'll say, well, can the purchaser still assert a breach based upon an implied warranty of merchantability? And what they're testing is, again, your knowledge of the rule. Okay? Everything else might be able to be done in a more generic way, but the implied warranty of merchantability has to be specifically named. You've got to call a thing a thing. Okay? So that's that issue. The other warranties at play here are the implied warranty of fitness for a particular purpose. That's 2.3.15. And with the implied warranty of fitness for a particular purpose, again, there are specific elements that have to be satisfied in order to establish it. Okay? So you've got to know the rule associated with it. Okay? So specifically, the seller, when at the time of contracting, has reason to know any particular purpose for which the goods are required, and the buyer is relying on seller's skill, judgment, and advice, essentially. Okay? So if I have a buyer purchasing from someone and the facts tell you that the seller really is not experienced with this, guess what I don't have? An implied warranty of fitness for a particular purpose. Okay? Because the seller does not have the skill, right, or expertise. The buyer is not relying on the skill and expertise, even if the seller knows the particular purpose, right? Again, they are testing what you remember about the rule. Okay? So understand that if I could say the fitness for a particular purpose is a higher purpose warranty, right? We're looking for a conversation. We're looking for those elements being satisfied in the fact pattern in order for that to be applied. Now, what's interesting, because I want to talk about the exclusion aspect of this, you can disclaim an implied warranty of fitness for a particular purpose with generalized language. Okay? You can disclaim your express warranties with generalized language. It's only that implied warranty of merchantability that needs to be written and conspicuous and call a thing a thing. Okay? Subsection 3 to 2.3.16 specifically talks about this. As is, without faults, all that other kind of stuff. Makes it plain, et cetera, et cetera. So it'll give you some suggestion within the rule itself as to what you should be looking for in the fact pattern. Okay? Does this make sense? Okay. Next thing I have is 2.207. All right. So 2.207 is not as bad as you think it is. Okay? The first thing I want you to remember is that we need to figure out who the parties are. Okay? If my seller and buyer are merchants, they're going to be treated differently. Okay? What is a merchant? Dare I say, take a look at 2.104. Look at the definition. It's not just somebody who's doing business. Okay? It's someone who is holding themselves out as having skill and expertise with regard to goods of the kind. It is someone who represents themselves as having skill and expertise with regard to the practices related to the goods of the kind. Okay? So, if I make a bunch of cards today and decide to sell it on Etsy, right? I may not necessarily be a merchant, or I decide to go to a craft fair. I'm a seller, but I'm not necessarily a merchant. Okay? So look at your fact pattern, see what they're telling you about who your parties are. So then, 2.207 is about the response that is received. Okay? It is about the battle of forms. Okay? So I have one party, and I'm not going to say which one, because I don't know how the fact pattern is. I could have a seller offering to sell. I could have a buyer offering to purchase. Okay? Your focus is the response that is received. Okay? So what you're receiving is a definite, seasonable expression of acceptance or a written confirmation which is sent. Okay? So what is coming back after the offer to sell or the offer to buy is either a expression of acceptance, could be verbal, or it could be a written confirmation that I'm looking at. Hence your battle of forms. Okay? We're looking at the language. Does it offer additional or different terms? Now this is where 2207 deviates from common law. Okay? Common law, if I give you an offer, your acceptance has to be the mirror image, right? No modifications, no adjustments, otherwise it's a counteroffer. In UCC, we allow for some variation. We need to know how you're expressing it. Okay, does this make sense? So, subsection A is what I'm focused on, right? Think of this as step 1 in the analysis. After I've determined who my parties are, I'm looking at the language of the expression, what has been said. Okay? 2207 subsection A talks about additional or different terms from those offered or agreed unless the acceptance is expressly made conditional on assent to the additional or different terms. Okay, my favorite thing to pick on. I've got a contract for apples and bananas. That's my offer. Sorry. I have an expression of acceptance which says, I'll give you your apples and your bananas, but I also have a shipment of cantaloupe. Are you interested? Okay. I also have a shipment of cantaloupe. Are you interested? Now, is that additional? Yes, it is. Is it different? Yes, it is. My offer is apples and bananas. My response was apples, bananas. Well, what about the cantaloupes? I've got some. Do you want them? Okay? What that expression of acceptance does not do is make the acceptance expressly conditional on offeror's acceptance of the cantaloupe. Did you see that? Because the acceptance was, I've got some cantaloupe. Are you interested? Okay? I clearly have an expression that is not the mirror image. So at common law, that response would be thrown out. It would be a counteroffer. But with UCC, no. I can have additional or different terms. I'm looking at how they've presented it. Okay? So if they're presenting it as, oh, I've just got some cantaloupe, are you interested? That's an additional or different term that has not been made expressly conditional. Okay? And if I have that, I go to paragraph 2, subsection 2 of 2207. Okay? So remember at the beginning when I said I need to know if I'm dealing with merchants or not? Subsection 2 tells me why. The first sentence of 2207 says additional terms are to be construed as proposals for the contract. So I've already analyzed my response. Apples, bananas, what do you think about the cantaloupes? Are you interested? Those are additional terms. They've not been made expressly conditional. My buyer and seller are not merchants. Or at least one of them is not a merchant. That additional cantaloupe term is just a proposal. Okay? The facts have to tell me whether that proposal was accepted or not. Okay? If it doesn't tell me, and one buyer or seller is not a merchant, then I'm in subsection 3. And subsection 3 says, if the parties act like they're contractually bound with each other, that's where we'll find the contract. So subsection 3 says, well, y'all are acting like you're in a contract because buyer has already shipped your apples and bananas. I don't know what's going on with the cantaloupe. Subsection 3 says, well, I'll find the contract where these two things look alike. Okay? Now, what happens if I have merchants? The second sentence of 2207 subsection 2 says, between merchants. If you go back to 2104, the second paragraph says the phrase between merchants is a term of art, and it means that both parties have to be merchants. Okay? So if one party is a merchant and the other party is not a merchant, we're in sentence 1 of paragraph 2. If both seller and buyer are merchants, we're in the second sentence of 2207. Okay? And that says, between merchants, such terms become part of the contract unless, okay? So the assumption is reversed. If both parties, seller and buyer, are merchants, then it all, we assume, is part of the contract, unless you do something else. And what are those things? 1, the offer expressly limits acceptance to the terms of the offer. So what did we just do in subparagraph 1? We've already resolved that, right? Option 2, they materially alter the contract. Well, I've just used fruit, so I don't have a material alteration. 3, notification of the objection of them has already been given or is given within a reasonable time after notice is received. What is that? My offeror says, yeah, I'm really not interested in cantaloupes. Thank you. Okay, does this make sense? So all you have to do is go step by step, right? 2207 is not as confusing as people think it is, and I just think, you know, you need to think about the document, you need to think about the goods that are involved, you know, you think about the fact pattern that they give you, right? And you just go step by step by step, layer by layer through 2207, and it makes sense. 2207.3 is that catch-all provision. So because we're dealing with a variety of industries for UCC, and some of those are cash basis, and some of those, the goods are being shipped before the paperwork ever arrives, okay? Subsection 3, in reality, of 2207 is for those industries where, okay, technically on the paperwork it doesn't look like you had a contract, but you all are acting like you have a contract, so we're just going to do that matchy-matchy game and say where it looks like you guys agree, that's where your contract, and everything else is going to fall away. Okay? They're just trying to deal with the reality.
Where I get confused with this rule is I don't know when something is materially altering the contract. So, like, I'll have a multiple choice question, and I'll think, oh, well, that is an alteration that seems material, and then it'll say that it wasn't. So I don't know where the line is, I guess.
So the first answer is depends on the subject matter. Okay? If I have apples and bananas, but now you're asking me for office furniture, right? There's a material difference. Whatever that additional or different thing is, it's having a material impact on what the primary agreement is about. Okay, that's kind of what you're looking for. So, and they should give you some fact that tells you that.
Doesn't that also include like remedies, like if there was like they're saying you can't have that defense or rights and obligations under the contract are generally supposed to be that's material altering?
Absolutely. So remember that phrase, I'm disclaiming all express warranties. If I've got one document, my offer, that says you agree to be responsible for consequential damages, and the expression of acceptance says I'm not going to be responsible for any damages, especially consequential damages, those are different terms, right?
So what about like with an arbitration clause? Is that considered material?
Well, I mean, it depends on the impact, right? There's that, again, what is that case? What's not the Apple computer, but the one with the cow? Gateway, was it? Okay, the cow box. I'm sorry. So their arbitration clause required you to go to Europe to file for arbitration. Okay? So that's a clause that materially, right, impacts buyers in the U.S., right? You can have arbitration, but you got to go to France to go file your complaint. Okay? So the facts have to kind of guide you. Okay. I forgot the third-party beneficiary issue. That was the only last thing I want to do, so give me 30 seconds, or a minute or so to do that. All right. With third-party beneficiaries, the key is distinguishing between the intended beneficiary and the incidental beneficiary. Okay? So I'll definitely explain more about this when we go through the individual problems, but right now what I wanted just to talk about is that particular difference. Okay? Now, factually, within the problem, the two primary contracting parties have to intend for a third party to benefit. Okay? So what are you looking for? The two parties name the third party beneficiary. The third parties discuss that the contract is supposed to benefit a third party, right? There is an intended third party beneficiary. That third party beneficiary who is the intended beneficiary has rights. That third party beneficiary, one of the contracting parties can assert claims against. Okay? Your incidental beneficiaries have no right to enforce. Okay? So that's your primary distinction. Was the third-party beneficiary intended to benefit as part of the primary contract? Are they merely incidental to that? Okay? So that's the short answer, right? So again, you have to look at the fact pattern, right? What are they telling you? Are they discussing this is for the benefit of somebody else? That's why we're entering into this contract. They're an intended beneficiary. Okay? So that's your key to everything else. And then assignment and delegation we can discuss later, but essentially it's this. You assign rights, you delegate duties. Okay? You assign the right to receive performance, you delegate the actual obligation to perform. Okay? When I assign a right, the person to whom I have assigned the right has the obligation to enforce when they have given notice. Okay? With the delegation of duty, the person who transfers the duty remains liable, but secondarily liable. Okay? Because we want to make sure that the performance obligation is actually performed, if that makes sense. Okay? So if the first contracting party is required to perform, obligated to perform, and then they delegate that performance to somebody else, the first party is still liable. They're just secondarily liable. Does that make sense? Now, can the other party to the transaction object to the assignment and delegation? With regard to assignments, not. Delegation, yes. Okay? Why would a party object to a delegation? Well, if they believe that their performance is not going to be received. Okay? If I contracted with if I contract with Da Vinci for my portrait, and Da Vinci decides I'm going to retire from painting, and I'm just going to get my scribe to put a couple sketches together for you, I'm going to object to that delegation, right? Because the delegation is going to undermine my ability to get the performance, the benefit of the bargain that I contracted for. Does that make sense? Okay, so you delegate obligations, you assign rights. All right, okay, my lecture part is over. I think I've covered everything that you identified for me. If you think of something else at the end, let me know. I'll hang around after we do the problems and after we go through the problems. If you still have something that's lingering, let me know.
All right, guys. Today you're going to have 33 contracts questions. You have 1 hour to completion. Do not open questions until I tell you to. Yes.
Love MBE question cards. And hide. Yeah, no, please don't get Carol, that's what I'm gonna do. I'm gonna knock the bed.
So if it rains, take that.
For that day?
Yeah. Well, I guess it
Right? So I have a contract that says I own your grass. One of them I need to check.
Yeah.
I'll let it rain.
Yeah.
And it's only
Got it. Okay. We're gonna cut your grass today. And then they have to create it. Okay. And then with the buyer and the seller and risk of loss. So with your example of FOB buyers, please, and the delivery comes
The seller is still responsible.
I hear you. They're responsible for the goods, but what about if they buyer is stable for like sorting the goods? Say they brought it on a weekend and now they're 3 days and a night.
Well, hopefully, so you get the practice, right?
Yes.
If, and again, the contract doesn't right? So the contract says, look, you deliver by 6 o'clock. That's when our office is closed.
Yeah.
That's when we have to place it to protect the goods. Seller knows that if they're late, it's on them.
Yeah. Okay.
Right?
Yeah.
Because they needed to enter into the right contract to get the goods. Okay, does that make sense?
Yeah, it does.
There are possibilities.
Oh, that was the first one. You had to take this.
Right?
Yeah.
So if that's the case, then the seller has to give the buyer notice that yes, I placed it in your facility with your guard. Here's your paperwork, access. That's part of the tender.
Okay. Sounds good.
Does that make sense?
Yeah, it does. So I'm still a little confused about so like if buyer orders something from Walmart and they ship it to Walmart and they say, hey buyer, this is ready for you whenever you pick
And
it up.
risk of loss is when they give you.
I know.
That sucks. So that's interesting because on the video that I watched the other day, they said that usually that's not how it works. The sellers don't their risk and the buyer does.
Yeah,
So
so
is
that's
there-
typically how it's negotiated. So again, every time UCC gives you the first three words of
Okay, so that's like
So the reality is, yeah, the seller will
yeah, but based on
That's what Kentucky is. Definitely not into that either. So.
I was thinking,
from a lot of, I mean, I just want to like the seller, the okay? But they were also crappy. So,
Yeah.
like, it arrived at my house, but then I got a separate email to
Yeah.
right? So essentially, they are shifting risk of loss. Or we delivered it.
But they wanted to do it on your.
Yeah.
So they're kind of like going all for it, you know.
So that's just the using the technology to shift that issue. Thank you.
I know. And I wish we got a report back. I don't even, that's the funny part, you could be so tired.
You guys think of any other question before you get started?
No, I know, I have no idea.
No?
I mean, I think I did that on you guys.
Did that help?
I'll let everyone know.
I will.
Don't you wish the MBE gave back like a report?
Oh, like what, subject?
Yes, yes, but I have no idea.
Yeah. I mean, that'd be kind of nice.
It's kind of nice, like, even half of the time. You do this basically half of the time. You get like a 130. Let's say add 20 points or whatever. Weird.
Oh, they're probably different. We have to get a 130 or 135 to get
Get a 132, but we don't know how much scale score they add to it. That's what it's tough to do. I don't know
how many actual
that.
what do you need to get? Like, do you really need 130 or do you need like 115?
15 to 20 or so. Yeah. Yeah.
I'm going to improve.
You work on it on evidence.
No, I haven't done my evidence yet. I probably need to. I think it's like, I have a written schedule. I wrote this story about Barmax, so I'm kind of just incorporating Barmax into my written schedule because I have like essay days and stuff where I'm doing state subjects and flashcard review and stuff and MBTAs. She told me I should do an FBK week, which I hate. I really hate MBK.
Hate it. Kentucky added that.
I know.
Another thing is the evidence, which we not into that either. We already have it. And I feel like
I only do That's the first thing. Yeah, we get 2 for our first half of the day, then we do lunch, and then we come back and get 6 of them. And then the written portion for us is over at that point, but you have 30. Yeah.
We're only kidding.
Right. I mean, I like this thing. But at this rate, I think I'd rather go back to having 9 essays and get rid of the one that's on the deal.
What we said there,
every state's different on the report.
Yeah. So I was talking about, mapping your strategy.
Yeah, I've already started to work on
And however you work with it, I'm a very so even after I was trying to
at all, but they get weird. You have to do a course after the fact, so I'm saying. I mean, I think I prefer breaking it up. Right? It's really hard to memorize all the 10 pieces for time.
I hate Where's the problem here?
I want to react the same way. Like, what do you do? Like, it's happening, right? I mean, you really want to. If buddies are fast, I try to follow them and ran away to the middle. That will help you.
All right, guys, I think everyone is back. So again, you're going to have 1 hour to complete these 33 questions. I do ask that if you finish early and you leave the room, be respectful to the other students who are still taking the test, and be respectful because there is a class at the end of the hall right now. So just try to keep the noise down. Does anyone have any questions before we start? Does everyone have a test? Is everyone ready? All right, you may begin. this one harder than the evidence one? I know people were still working at time this time. And evidence was a little bit harder.
I think it's also Barbara, yeah.
Okay, so we're alongside.
I almost didn't think I was gonna make it.
What?
I almost didn't feel like I was gonna make it. And he just, I was like, I'm taking your time, girl. Well, I kept drifting, and then I like hear a noise, and then I was,
Yeah.
MBE Contracts Workshop, there's so many people that more, yeah, it's more tricky, because it's like, because after what she said, it makes me think about it. Yeah, Christian, is it real?
Right.
Am I leading myself down a rabbit hole, which is most likely, like, the sound good? Some were like, this sounds really wrong, like, I don't feel like you're here. I was like,
Right.
the symbolism for my life.
Yeah.
I was just, yeah, some of them I just get like, this seems the most interesting.
Yeah. I didn't know what 26 was talking about.
Okay, guys, you know the drill. Barbara puts the question after the answer explanation, so everything is out of order. But Professor Bolt is going to go through the questions with you. You have the answer explanation. Correct answer, the number corresponds with the letter. So 1 equals A, 2 equals B, 3 equals C, 4 equals D. And I'm going to leave you guys to it while I go take care of lunch.
Okay, all right, so the first question with the owner, who owns the farm, and the tenant. The correct answer is D. So my question is, how many people got D? How many people, well, let me just say how many people got D. Okay, so let's talk about why D is the better answer, given the choices that you have, okay? So we've got this owner of the farm, and he is, has a contract with the tenant to erect a barn with a milking station. After the agreement, the tenant moves himself and his family on the property. The farm owner, who has worked for many years as a skilled building contractor before retiring. Okay, you see that phrase there in the middle of the problem? The question has to be, why did they give that to you? Right? It's an additional fact. It's something else other than the lease. So it's a key fact that they want you to zone in on. Okay. Began the work on the barn, however, an injury prevented him from completing the job. He tells the tenant that he would see to it that the work was completed and that he had already entered into an oral contract with the nephew, a novice contractor, to finish. So here's a situation where this is where you might think, oh, this is going to be a third-party beneficiary issue. Right? Because the farm owner is contracting with somebody else to finish the job for the benefit of the tenant. Okay? The contractor's, it's a separate contract, but the tenant is benefiting directly. Who is a novice contractor. Okay? So remember that key fact that we had earlier that was kind of a little bit out of alignment with what you thought the problem was going to be about. This other fact sort of connects with that, right? So we had a skilled contractor with an oral contract with a novice contractor, okay? However, the nephew failed to complete the job. The tenant brought an action against the nephew for breach of contract, which would be the best defense, So let's talk about A. His contract was with the farm owner and not with the tenant. Does that matter? No. Right? Because we already talked about there's sort of an intended beneficiary issue here. So the fact that the contract was between the farm owner and the nephew, the tenant would be the third-party beneficiary who is an intended third-party beneficiary and would be able to bring a claim. So the way they've stated A, it can't be the answer. B, the tenant furnished no consideration. Again, we don't care. Why? Third-party beneficiary. Okay, that can't be the better defense. C, his agreement with the farm owner was oral. Do we care about that? No. Right? Statute of frauds. Performance is to be performed within 1 year. Doesn't have to be in writing. Okay? So the fact that it's oral is not the key answer. So that leaves us with D. Okay? Now, does that clear up any questions with regard to that? Yes, no. And trust me, there are going to be some that we're going to go, okay. We're learning to understand how they write the questions, okay, and how to figure out what the best answer is. So it's okay if some of these, you may not agree on. All right, number 2, the correct answer is C. How many people got C correct? How many people picked D? Yeah, I'll be honest, I picked D. Because honestly, D is technically correct. So the issue here is, why did they pick C? That's a better answer, okay? And so whenever you do this in practice and you go over your questions, go over why they figured out that was the right answer as opposed to what you selected. Just don't accept the fact that you got the wrong answer, okay? Because what you want to teach yourself is what signals we're finding in the question that will lead us to the answer, okay, that is wanted in the test, okay? So just be open to that. So let's talk about this. So this is a grandfather who told his granddaughter that she could have the house. He promised her that he would have another wing added to the house in the back. He entered into a contract with the builder to construct the addition for his granddaughter. Now, this is what led me to the issue of incidental versus intended beneficiary, right there, okay? So before the grandfather entered into the contract, the granddaughter had paid $5,000 for a 60-day option. However, the grandfather showed her the plans for the construction. She liked it. She decided to let the option lapse. And then you have the zoning issue, which requires that the addition be put on top, not in the back. She had already let the option lapse. She discovered the addition was now going up rather than back. She demanded that the builder either build the addition according to the original specs or pay her for damages. The builder refused, and the granddaughter filed for suit. Okay? So the issue is, who is likely to prevail? Okay? Here's the problem. The first thing you should do is figure out who you think should prevail. Builder versus granddaughter. Granddaughter really doesn't have a claim here. Okay? So that helps you narrow it down to, it's got to be the builder. So you can eliminate the first 2 options, because the first 2 options are all about the granddaughter. Okay? And I decided it was the builder because of intended versus incidental beneficiary issues, and I thought the zoning was an impossibility that didn't give her a claim.
There's nothing in the fact pattern that states that the builder knew that the granddaughter was going to move, did it? I mean, that's where I got incidental from.
Yeah, that's where I got incidental too. Honestly, I got incidental because, because it wasn't known in the contract it wasn't clear to me under the fact pattern initially when I read it. So in going back over the rationale, they are focusing on that part of the question that says that the granddaughter was an intended beneficiary, not an incidental beneficiary. And the only place I got that from in the fact pattern is where it says in the third line, entered into a written contract with the builder to construct the addition for his granddaughter. Right? It's the only thing that makes sense to me in the problem. You know, I would have thought that that was not quite strong enough, but in my initial run through these questions, but I see where they're going with it. Okay? So here's where I said, even if you got the wrong answer, we're trying to see how they are articulating these facts so that we can understand how they're getting to their answer. And that's going to help you select the best answer. Does that make sense? All right, so the C option says, the builder, because he may raise all defenses that he had against the grandfather, against the granddaughter. Well, yes, if she's an intended beneficiary. No, if she's an incidental beneficiary, right? So, since I was already thinking initially incidental, that's why I rejected C and I selected D. But in reading their rationale, that phrase, for the granddaughter, made her an intended beneficiary, not an incidental one. Okay? So then in D, where it says the builder, because the granddaughter is merely an incidental beneficiary, they reject that one because they're saying she was intended beneficiary, not incidental. Does that make sense? So that, again, is just teaching you how they're going to phrase the fact pattern, right? Those are the keys that we're looking for that may drive us toward a different answer. Okay? That help? 3. Okay. The correct answer is C. So this is the pet shop distributor. Distributor agrees to supply the pet shop with for 2 years of pet food, right, with an option to renew. The contract required that the pet shop buy its pet food from the distributor. For the first 6 months, the pet shop only ordered 10 cases of pet food. In the seventh month, the owner of the pet shop sold the shop inventory and accounts to a chain. As part of the sale, the pet shop assigned the distributor contract. The chain operation promptly notified the distributor of the sale and the assignment. That same month, looking to stock the pet shop in stores throughout the chain operation sent the distributor an order for 5,000 cases of pet food on the terms and conditions of the agreement expressed in the contract. The distributor did not have the means to fill such a large order and refused to deliver the cases. So if the chain operation brings suit to compel the distributor to fill the order of 5,000 cases of pet food, who will prevail? Okay, so does anybody remember what case this reminds you of? Because immediately I thought of the case. So this is an issue. It's a 2306 contract where you are supplying all of the needs, right, of the purchaser. Okay, so that's the issue where the only way the supplier in that supply contract, output or need, right, output or requirements contract, the only way that there can be an objection is if the request is unreasonably disproportionate. So here's an example of where you just need to know the rule, right? You recognize that this is a requirements or an output contract. You know that there has to be a substantial deviation. Well, they've given you a substantial deviation, right? 10 cases as opposed to 5,000 cases. That's a substantial difference, okay? So if you know the rule, then you're starting to eliminate your options. So A, the chain operation, because it gave the distributor prompt notice, from the pet shop, it purchased. That clearly is not about notice. It's about unreasonable disproportionality. B, the chain operation, because it would not be impossible for the distributor to acquire the quantity that the chain operation requires. Well, that's not the issue. right? Or they can get it elsewhere. They're telling you that they can't supply this amount. The distributor, because the quantity required by the chain operation is too great compared to the pet shop's needs, and thus the assignment is not enforceable. Okay, well that starts to look like our unreasonable disproportionality, doesn't it? B, the distributor, because there was no mutuality of obligation in the original contract between the distributor. Okay, that's the mutualization. Okay, it's not an issue of mutuality of obligation, right? This is an output requirement. And if you remember, hopefully, when you studied mutuality of obligation, mutuality of consideration in contracts, that the requirement for the output contract was a deviation from that general rule, right? Particularly under Article 2. Okay. Question? So a couple of things I did want to mention with that. So this was a really good problem. That particular rule, if you go back and look at it, it has a couple of deviations which would make great multiple choice questions, okay, to really test that unreasonable disproportionality aspect of it. Because the rule itself talks about a stated maximum or minimum, or it talks about a stated range, okay? So I could see a variety of fact patterns being developed with this particular rule that, again, tests the extent to which you know the rule, okay? So really pay attention. They've made the facts really obvious that it's 10 cases versus 3,000. They didn't necessarily give us a stated maximum or a stated minimum or a stated range, but they certainly are triggering that unreasonable disproportionality issue. Okay? So just look for that variation of facts and anticipate that particular rule. And then the case that I was trying to remind you guys of, there's an ice cream case or ice supplier case for an ice cream company case that tests this notion. And it was a requirements contract with a small mom and pop ice cream. Small mom and pop ice cream sells to like Breyer's ice cream. And so the ice supplier was always at the max instead of having these ebbs and flows in the supply. Unreasonable disproportionality was the issue. Okay? All right. 4. I won't spend, I know there's 30 some odd questions, so I won't spend quite so much time with all of them, but I just want you to be able to, start paying attention to what signals the issue. Okay. This one should be a little troublesome, I think. 4. The answer is D. How many people got D? Okay. How many people selected D, maybe? Yes. Okay. I thought it was C, personally. So this is one we have to really sort of pay attention to. And I'll point to the fact that led me in this direction. Okay. They entered into that written contract for the improvements for $5,000. Shortly after the contract was signed, the contractor told the homeowner to give the money to his daughter. Quote, "She is getting married soon, and I want her to have a nice wedding present from me." The daughter was aware he made this statement. She married, but soon after, of course. Now, she was already planning to get married. I completely missed the reliance issue because of it, right? She didn't change her position as a consequence of the statement, right? She was already going to get married. So that's why I missed this problem. So I think what we have to understand, again, is how they got to the answer that they got, right? And I think this is one where they're eliminating all the others, okay? I just thought reliance was a ridiculous answer because she was already going to get married, right? So I just wrote off the 4th option right away, okay? So, I mean, I want to be honest about that, right? Because I think that's helpful. I mean, if I tell you, yeah, I got the wrong answer too. And this is why I got the wrong answer. So let's understand what answer they're thinking of, okay? So they're making the argument, they do argue detrimental reliance, But I think partly it's because they're rejecting everything else, right? So statute of frauds, is that the best argument? No. Okay, this is not a statute of frauds problem. In terms of B, the parole evidence rule, well, we've spent some good quality time with the parole evidence rule, right? In our filling in the gaps of understanding. So we now know there is nothing about this that the parole evidence rule would apply to. Okay, so that eliminates A and B. C, the daughter was an intended third-party beneficiary. Honestly, I thought that made more sense, given how I had already eliminated the reliance issue, right? But they are rejecting it because they said she was not an intended third-party beneficiary. And their issue here is that the third party must, the assignment of the contract is not did not contemplate performance to a third party at the time it was made. Well, that's actually correct. But I thought the reliance issue made absolutely no sense because she was already getting paid. But I see where they're going with that. I mean, they are technically correct that at the time the contract was made, she was not an intended beneficiary at that time. So that's why they're saying intended beneficiary didn't make any sense. So this is a little tough one. I mean, I'm just going to say for that particular reason. But again, I think the only way I can explain it is that knowing what the rule is, right? Technically, when he made the contract, he did not mention his daughter. So the issue of intended third-party beneficiary wouldn't work. And that would leave you with the one. Okay. Five, answer is A. The carpenter only. Do I need an explanation for that one? How did we do? Yay? I'm seeing lots of nods. No one's waving their hands in desperation. Okay. I won't spend much time on that one then. Yeah, okay. The carpenter. You can successfully prove damages. Okay. Now I'm going to move on to 6. The answer is A. Hearing a lot of grumbling, so we'll go over that one. All right, so Wealthy Sportsman is determined to win the title of the sailing competition. July 1 approaches the builder with a whole design. The discussion resulted in a valid contract whereby the builder agreed to build and completely outfit the sail and all auxiliary equipment on or before next April 1, the day when the crew had to begin training. The agreed price was $2 million, payable on May 1. The builder assigned the right to payment to an assignee. The boat was not ready on April 1 or May 1. The sportsman did not make any payment. So as of May 1, who can the assignee sue? Okay, it's an assignment, so the assignee has the right to receive payment. But that right to receive payment is conditioned upon the builder actually performing. There are still obligations remaining. So the only logical person who can be sued in this scenario is the builder. Okay? The performance of the construction is technically a condition precedent on the sportsman's obligation to pay for the boat. Okay? Does that help? What? All right, 7. The answer here is D. And it's a third-party beneficiary problem. Okay, any confusion about 7? Not seeing any? Moving on. I see a question, yes.
I don't know, is there like a, never mind.
You figured it out? Okay. Okay. 8. The answer is A. Not hearing grumbling. Going by your grumbling. This is, again, just knowing what the mailbox rule is, what it isn't, what it applies to. Okay, mailbox rule only applies to acceptances. Everything else is effective upon receipt. Okay. 9, the answer is B. Everybody's good on that? Yes? Yes.
Just a quick thing, so if he returned the dog first and then found out about it, he would be able to get paid.
Yes.
Okay.
And here's the thing I want you to pay attention to in that problem. The performance was twofold. You had to find the dog and return the dog. That was the performance called for in the offer.
If you didn't know about the offer to find the dog, you already found the dog, how can you accept the part?
Because he had to do both things in order to qualify for, he found it, but he hadn't yet returned it. Both things are called for in the offer in order to accept.
You didn't know about the offer for 500 when you found it.
But he did before he returned it. Right? So, B, yes, because he completed both mechanisms of performance in order to accept the offer. Okay? So that's the issue where just reading, again, I've always said this to my students as well. If you see something in quotation marks, pay attention to it. Okay? You see a quotation, you see that big "and" sitting there. That's going to tell you that this is an offer for a unilateral contract. You have to fully perform in order to accept. There are 2 parts to the performance. When he finishes the second part, okay, and he's entitled. Yeah.
So if it had just said, I'll pay 8,000 to anyone who finds my dog, would it still be the same one?
I don't think it would be, right? Because he has to know, that that is the offer that's out there, so that it's a part of a manifestation of mutual intent to be contractually bound. And the issue is when he goes out to find the dog, does he do so with the intent to accept the offer, right? So there we have a different issue. But the offer is calling for 2 parts of performance, and so when both of those 2 parts of performance are completed, he's entitled, and we're less concerned about him finding out about the offer in the middle. Answer is B. I hear no grumbling. Now, again, this is just, but you all are giving me that look. So, is this something I need to just review the rule or what? So some of you are not necessarily grumbling, but you're giving me a look.
So what is the counteroffer, I guess?
So here's the deal. This is a UCC problem, right? 2204 says that an offer which calls for shipments in order to accept the shipment of either conforming or non-conforming goods is an acceptance of the offer unless it's accompanied by an accommodation language. Okay? So this is the deviation from common law, right? Because common law, this would be a nonconformity. This would not fall within the mirror image rule. And so therefore, this act under common law would be interpreted as counteroffer, right? Under the UCC, 2204 says you're shipping, right? Whether it's conforming or non-conforming, that's an acceptance of the offer. But think about it, upon delivery, the buyer would still have the option to reject, right? Or would, at this point, sue for breach of contract related to non-conformity. Okay? So, again, that's just knowing 2204. Or 2206, I'm sorry, 2206. Not 2204. 2204 is firm offer. 2206 is the acceptance one. So 11, the answer is B. How'd we do on that? Hearing no objection, okay. Well, the answer is B. Ooh, I heard some sound. Let's talk about that. Okay, so here, point number 3, read with precision on this one, right? The dates are critical in this. So we've got a written agreement on June 1. It says, I'll agree to sell the 1 acre. The offer shall remain open until July the 15th. And if it's accepted, the closing will take place on August 1st. Buyer paid the seller $10 on June the 1st. Now, the significance of the $10 keeps the offer open until July 15th, right? But the language of the option says July 15th is the end, right? So later in the problem, it tells us that the letter received by the seller was not until July the 16th. That's the day after. Now, why isn't the mailbox rule kicking in? Because it's an option.
That makes sense, huh?
Right? It's an option. Okay? The offeree has paid to keep the offer irrevocable until July the 15th. The response has to be received. Mailbox rule is not going to help the offeree in this context because it's an option. Okay? That's right. That's why we're doing this. It's okay. All right. So, again, the dates matter. Recognizing that we have an option and knowing what the rule is are 3 key components to that. Yeah.
At what point is consideration nominal? Because I thought $10 was, for $100,000 contract.
Doesn't matter, right? It's bargain for exchange. If that's what the offeror calls for in exchange to create for the purpose of creating an option, nominal consideration is okay. Okay. In order to create an option. All right. Right? But the dates matter. So there was a couple of moving parts there. So because he accepted the offer before July 15th, that the D answer, that's just because they're testing your knowledge of when the mailbox rule applies and when it does not. Okay? Any other questions on that one? 13. That's okay. This should also help you, in terms of number 2 here, identify anything you need to review, right, in your own study to make sure you know what the rules are. Okay. 13. Answer is C, waiver of condition. I need to review that? No? Is everybody sounding pretty good on that one? Okay. I was given very strict instructions not to bring anybody to tears today. That's what my goal is. That's what my goal is. Help you understand. All right. 14.
Really?
Option is B. Oh, then I'm going to give you my grandmother's advice. Pick and choose, best refuse. Right? When you're thinking one is the answer, review why you think that's the answer. Don't have confidence. Right? Because somebody just said they had the answer, then they talked themselves out of it. Okay? Trust your gut on something, because you only have so much time for every question. So that's an irrevocable waiver of the condition. Anybody need to review that in terms of understanding the law? Not seeing any. Moving on. 15. The answer is B. Here's some grumbling. Let's go over that one. So, buyers enters into a contract with a retail seller for 3 computers of a specific brand for $4,500. The computers arrived. The buyer saw that they were a different brand, so he already sees that there's a nonconformity, right? But the law says what? The buyer, when they receive goods, they have the opportunity to do what? There you go. Okay? So because he was short of computers, the buyer asked the secretary to use the computer. 1 week later, the secretary complained about the computers, and therefore the buyer wrote to the seller that he was rejecting the 3 computers that were sent to him. What is the legal effect of the buyer's retention and use for 1 week before notifying the seller? Okay? Now, if you've had UCC with me, what did I tell you about that inspection? Depends on the nature of the goods. What is required to inspect it is whatever the nature of the goods calls for in order to inspect it. Do you know a computer works without turning it on? No. Okay? And they can test it out for a reasonable period of time. So the facts already said 1 week. Okay, so that's knowing what the rule is, what is required with regard to inspection, that's manner of acceptance. 2602.
Other question. So you still have a reasonable time to inspect even when you know the goods aren't conforming. It's not just the goods are conforming, I'm going to inspect them just to make sure they work properly or whatever. Like,
yeah, because he may decide, well, they're not the ones I ordered, but they may work, and I'll still accept it. Right? So the buyer still has the opportunity to inspect the goods to make the decision of whether they're going to accept or reject. Okay? Now this is distinguished from, you might remember the problem in the commercial law book where the person receives the computers and drills holes into it. Right? Well, now they've made, in order to attach it to their desk. Well, that's not inspection, right? That is taking action which is contrary to the interests of the seller. That constitutes an acceptance, right? But again, think about what the nature of the goods is. How do I know the thing works? Okay. So A, because the buyer was aware that the computers were not the branding ordered, yes, he did know that, but he still has the opportunity to accept as a buyer. Okay. C, not an acceptance because the computers were non-conforming. Well, he hasn't made the decision to accept yet, and they're telling you he's made the decision to accept. We know the rule. Buyer has an opportunity to inspect. Okay? And then D, a waiver of any claim against the seller on account of non-delivery of the computers. No, I mean, there's no waiver. Okay? We're still in the process of making the decision whether to accept or reject. Does that make sense? So B is the most logical answer, and it, talks about reasonably required to test the computer. Yes. That is the system. Okay. All right. 16. Answer is B. Breach of the implied warranty of merchantability. Now, this is contrary to the rule, isn't it? Yeah. Right? Okay. Because, the language, remember I said under disclaiming of the warranty, subsection 2 there, you have to say merchantability, right? What's in bold to help us out here, hereby disclaims any and all warranties expressly implied, including the warranty of fitness for particular purpose and the warranty of merchantability. That seems pretty clear, conspicuous language, written, blah, 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 right? Conforms with the rule. But the issue for us is the thing blew up, right? Under which of the following theories will the consumer most likely recover? Breach of an express warranty? Clearly not.
It wasn't that clear.
All right, that's fair. That's fair. So let's kind of talk about that one. So the explanation is that they're saying no clear express warranty was made as to quality at the time sufficient to become part of the bargain. An express warranty will arise from an affirmation, et cetera, et cetera. We know that. Here, there was no such affirmation, promise, description, model indicating that the television would not explode. That is something that would be understood or implied. Okay? I don't know. I mean, where it says in quotation that the store expressly warrants that this set is free of manufacturing defect for 30 days, if the set is defective, the store's liability will be limited to cost of repair. Okay. I don't know. This seems pretty express to me. But so I understand why you were misled on that one. They're not going for that because they just think it wasn't. They're looking for something more explicit related to the explosion of the thing, right? So they didn't make an express statement that said this television is not going to explode.
So they have to say every possible outcome.
I think that's what they're looking for. They're looking for a very specific express statement to qualify as an express warranty. Okay? Now, the rule for express warranty is any affirmation of fact, a promise made by the seller to the buyer, or from any description of the goods, or any sample or model if the statement, description, sample, or model is part of the basis of the bargain. Okay? The warnings regarding the danger of electricity, I don't know. Maybe this has nothing to do with electricity. I'm not sure why the television exploded. C is clearly not correct because there was, remember I said the implied warranty of fitness for particular purpose requires all of those elements, right? They did not give you the facts for those elements, okay? There wasn't a conversation between seller and buyer. Buyer did not communicate to seller a particular purpose for which they needed the television. Seller did not give specific advice. Buyer did not rely on that advice in order to make their decision. Okay? So that's one where you just need to know what the rule is. Okay? So C cannot be the answer. D, breach of warranty of reasonable workmanship. I don't know where that came from. Right? Not what we're concerned about. So at least C and D can easily be eliminated. I think it's reasonable if you got a little mixed up on the A and the B answer, right? So because of how what they're looking for something a little more clear on the express warranty by elimination, process of elimination, it leaves you with B.
Fitness for a particular purpose. I guess you answered this in your lecture portion, but
it can never be implied. I mean, I guess I picked that because a TV has a particular purpose, and if it explodes, then I can't watch Netflix on the TV. It's
correct, but it's about the conversation. If you read that provision, right, it's about the conversation. So, problem from the book. The person who is the tennis player, right? French Open. Okay, I've been addicted. So, the tennis player goes to the tennis shop and says, I need a racket to play on clay. What do you recommend? The seller at the tennis shop says, these rackets are good for play on clay. The tennis player relies on the statement of the seller in the selection of the racket. That's an implied warranty for fitness for a particular purpose. Okay? So you're really looking for those key components in the facts. Okay? Good question though. Any other questions with regard to that? Okay. But yeah, I feel your pain. Felt your pain on that one. But again, that's one where I said you just need to understand what their rationale was and what they were looking for, so that the next time you look at one of these questions, you're looking for a stronger statement of an express warranty in order to select that option. 17, the answer is C. I hear no grumbling. Good. 18, the answer is C. That one is right out of Lucy Lady Duff Gordon. Right? 19, the answer is C. 20, the answer is B. Okay. 21, the answer is C. I hear some exhaling. Okay. So let's go over this one. 21. So again, this is the issue, the difference between, common law and UCC, right? Oral contract to buy 100 file boxes for an upcoming back-to-school sale. Wholesaler agrees to deliver the file boxes in 2 weeks at $4 a box. Yes, you have to do math. 4 times 100 equals 400. Okay? So the significance of that is that this contract can be oral. 2201 allows you to have an oral contract where the quantity, that is under $500. Okay? That's the threshold. A week later, the retailer phoned the wholesaler, asked if she could increase her order to 200 boxes. 200 times 4, that's going to get us to 800. That one may need to be in writing. Well, it absolutely needs to be in writing. Under 2201. The wholesaler agreed. The wholesaler delivered 200 boxes as promised, but the retailer accepted 150 upon discovering that she lacked storage for all 200. May the wholesaler recover damages with respect to the 50 file boxes that were not accepted. Your instinct, because you're feeling sorry for the wholesaler, is that you want to say yes. But 2201 says no, right? Because the contract for the sale of goods, where the value exceeds $500, must be in writing. This, in order to be enforceable. This is $800. Okay? Yes.
Well, I thought for this special law, if they really form special law to be satisfied with.
Go over that. Because I want to clear that up. Okay, so subsection 1 is what we're talking about. Okay? Subsection 2 is just between merchants. That deals with the writing and confirmation. They're still talking about a writing. Okay? I think are you possibly thinking about 2207?
I don't know, I was thinking
We don't necessarily have specifically manufactured goods here. Nope. So I'm just going through 2201, right, which is what this is testing. And we're not talking about the issue of with respect to goods for which the payment has been made and accepted before the goods were received. That's not our situation either. Okay?
I thought D was getting at, since it's a merchant, they can resell them and cover it.
Okay, so merchant buyer, or this is a merchant seller, right? What has happened that justifies this contract? You have to prove the existence of the contract. You have to prove the nature of the breach. Okay? Our problem is we can't prove the existence of the contract. Why? Because 2201 requires this particular contract for $800 to be in writing. If you can't prove the existence of the contract, how are we supposed to prove the breach of the contract? How are we supposed to get to the remedy? Okay? So this, I'm sorry, go ahead. No, I was just going to say, this is where I think in your study, right, you want to compartmentalize how these problems arise, right? So for contracts and for sales, it's like, what do I need to create it? What do I need to perform it and deal with acceptance, rejection, revocation of acceptance, breach of warranty, performance problems? Then how do I deal with remedy issues, right? You don't want to leap in your thinking over all those other two steps, right? So you want to compartmentalize what you're doing.
With the facts how they are, if they accept it, last in the hundred, so they breached the original contract, and they'd still be able to.
If this were still just the 400?
So all of their facts are the same except for the number that they accept.
But that's the problem.
And I'm saying is the breach would affect the original written agreement, right? The original 100.
Right, but the original agreement was modified.
Yeah.
See, that's why you're problem. When you said all facts being the same, the answer can't change. If it was the original facts, meaning 100 boxes for $4 a box, meaning I had a contract for $400. Now I have a contract that I can enforce under 2201. Okay? Now if there is a breach in not accepting the shipment, now my seller has a different remedy under 2703. Does that make sense? Okay, 22, the answer is D. Oh, I heard that. Okay. All right, so this is the rule related to installment contracts, okay? And specifically, it's 2-612. Okay, so let's go over that. So I've got a contract, signed written contract for the sale of 50 identical sets of fixtures. 25 are delivered on March 1, 25 are delivered on April 1. That gives me my installment contract. Okay? So now the issue is, what is the impact with regard to a disconnect on one of the installments? Okay? Are they being rejected? Are they being accepted? Wrongfully? Rightfully? Okay? All this sort of stuff deals with the installment issue. Right? So the agreement didn't specify the place of delivery. Okay, in the absence of delivery, what's our FOB rule? It's the shipment contract. That means the risk of loss shifts to the buyer when placed. Okay, right? It's not happening to get there. March 1, fixture company tendered 24 sets to the developer and explained that one was damaged in transit from the manufacturer. Fixture company promised to deliver a replacement within 5 days. Okay? Now, obviously, I'm asking for 25. I'm getting 24. One of them is defective. Is there a substantial impairment? Clearly not, right? I'm getting 24 out of 25. So the breach, if you're going to argue that, if you're going to think that there's a breach here, doesn't substantially impair the value of the contract. Okay? So if it doesn't substantially impair the value of the contract, we're dealing with, you have to accept it. Well, that's why you're eliminating number 1. Okay? Option A, because they're talking about a rejection. They're entitled to accept 24 and reject the rest, cancel the contract. No, they can't do that under the rule. Okay? B, the developer is entitled to, it says the developer is entitled to accept the number 24, reject the rest, but is not entitled to cancel the contract. Well, that starts to look right, but again, that's just not the rule. Okay? Because there isn't a substantial impairment to the contract, where I only have one that's not in compliance. So I can't cancel the rest of the contract. So if the option is cancel the rest of the contract, that has to be the wrong option. Okay? Because I do not have a substantial impairment. B, no, I already did B. Okay. Again, it says not entitled to cancel. Okay, it's not there. But they can't reject the rest. C, the developer must accept the 24 sets, but is entitled to cancel the rest. Nope, we just talked about that. Okay? That leaves D, which is aligned with 2612. Okay? Now, the only justification, I think, for getting, maybe it was, I don't know, which one did you select? B, maybe? Is the issue is that you're getting confused with the perfect tender rule, right? That's what threw you off. Okay? But remember, we're dealing with installment contracts get treated differently from non-installment contracts with regard to the perfect tender rule.
There was also something in the course that I was taking that talked about since there was still time left on the contract, that the manufacturer has time to cure the defect. So I didn't think about it until after, and I was looking at it, and I was like, that might be wise because they still had time to get that to it, and that's why it's not.
That's the other reason why we wouldn't support canceling the rest of the contract, right? We don't have substantial impairment, and seller has the opportunity to cure. Okay. 23, answer is A. 24, answer is D. 25, answer is A. Do I hear some grumbling?
Yep.
Yep? Okay. I heard that. So, A it tells us that the writer is entitled to keep the $10,000 because the liquidated damage clause was reasonable. Tell me what answer, if you didn't get A, what answer did you select?
D.
B and D?
She didn't even know why she was facing liquidation damages.
Okay. So here's a question we have to make sure we understand why they selected this one. All right. So they're talking about they keep the 10,000 liquidated damage, which will be enforceable. It qualifies for liquidated damages because the damages are difficult to ascertain. The damages are a reasonable forecast of compensatory damages. The test for reasonableness is a comparison between the amount of damages prospectively. Here the damages were difficult to ascertain, but $50,000 appears to be a reasonable forecast. The writer is contractually entitled to keep the $10,000 as a part of his liquidated damages. okay? B, the issue is, if you look at the answer here, the publisher is entitled to get 10,000 returned because its contractual duties were discharged by impossibility. Okay. Not an impossibility here. Okay? Impossibility only when the performance cannot be performed by somebody else, right? So you're talking about a risk event which makes performance impossible. They're not talking about impracticability, which means it's just more expensive, right? They specifically use the word impossibility, which means it can't be performed, okay? Now let's go to the facts here. So they talked about the reason why the publisher cannot publish is because of why? They're just in financial difficulty. Is publication impossible? No. They could have gotten somebody else to publish it, right? So it's a breach of contract, and the conditions do not render performance impossible.
Okay, my problem with this, because I think these are some of the best answer. I don't understand how the liquidated damages clause is reasonable when she wasn't actually sure what the damage would be, and she just thought she could make 50,000 royalties. It's not like she did any type of calculation to.
Well, but the rule with regard to, so what is reasonable? The parties are contracting for liquidated damages, knowing that there is no market to assess the value. Right? They're difficult to ascertain. So the real restriction on liquidated damages is that we don't want the liquidated damages to be punitive. Okay? But if the parties agree to a value for liquidated damages, right? And it's not unreasonable, it's not punitive. Okay? If it's based on projected warranty of royalties, then it's not punitive. Right? So liquidated damages don't always have to be nominal, right? That's what you're thinking, right? It's just whatever the parties think would best represent what the liquidated damages are designed to cover. Does that make sense? So I think the one caveat I put here is, obviously you're looking for that standard, right? You're looking for the elements of liquidated damages. It's difficult to ascertain. Are the damages reasonable? Forecast of compensatory damages. Well, if they're based on lost royalties that are projected, well, yeah, okay. They're based on some kind of measure, right? And just applying the thinking through the test for reasonableness, okay? That's what we're looking for. If it's punitive, if the damages were $200,000, okay, that's looking a little questionable, right? And they don't give us a reason for the $200,000, well, now I'm starting to think it's punitive, and it's not based on anything. Does that make sense? So, but they've given you a justification here. C, the agent is entitled to get the $10,000 because she performed part of the contract by finding the publisher. Yeah, we don't really care about that. Okay. D, the writer is entitled to keep $8,000, and the agent is entitled to 2 because the liquidated damage clause was reasonable, and the agent was required to 20% of whatever the writer gets from the deal. Well, that's not entirely what the deal was, right? They get 20% of, in the second sentence, they get 20% of what the writer earned from each copy sold, right? If there was no copy sold, then the agent is not entitled to anything. Okay, does that make sense? 26, C. Not hearing any rumbling. D, 27 is A. I think the bet, if you didn't get 27 correct, I think that all the others all the other options just don't make sense. I mean, if you were a little fuzzy on your integration before we went over parole evidence rule and all that kind of stuff, I think now that you understand it, you know, go through the other options and then just stop. Okay. 28, the answer is C. There's your condition. Right. 29, the answer is C. Not hearing anything. There is a difference, and that's reviewing a restatement issues. There is a difference between a release and a rescission, right? Okay. Release would require consideration. Okay. 30, the answer is D. '31, the answer is A. We're good? 32, the answer is B. Oh, I'm sorry. Where am I? 32. I'm sorry, I read 33. My fault. 32 is A. My fault. No contract between the farmer and the resident arose on June 2nd. That's just paying attention to the dates again. I'm sorry, that was my mistake. 33 is B. Is that it? That's it.
All right, guys, please thank Professor Bolts again for doing this. All right, there is pizza set up in the commons, drinks, everything. Please help yourself.
Smile. It's okay. Breathe. Now you know what you got to do, right?
11 out of 27.
Half would be half of 22 is 11. You probably got one. I only got 2 more pictures. They're like 13, 12, or 13. But what's funny is I literally would narrow it down and I'd draw an arrow to both like C and D, and then it would be like I would take D and it would be C, and I'd be like, really, Carly? Or like I circled it and I erased it and it showed the different answer, but it was really the same. Good times. I talked myself out of things. Or I just get like bored or tired or something, and I'm just like done with it. Some people like take their time and they do better taking their time. Some people, if you go through it really quickly, you do better. Like Raven goes through hers super fast, but she does really
Yeah, I
fast.
go really fast.
Like,
And I do better.
I can't find a happy medium if I drag too much, then I'm just like, gotta answer it.
Right? So it's like I keep being like, I have 1 or 2 topics that I just am not very good at, you know? But I can't be not very good at every single one. In everything. Like my brain cannot retain all that. Good. I got more than 10 right, so I'm happy.
It was substantially more.
Yeah, it wasn't a lot more than that. 8.
Gotcha.
You got 18. That's pretty good.
I'm not worried because we haven't.
I have to review the milk.
So do I.
7 for 10 every time.
I'm gonna go grab a slice and then I've got to go.
Okay. Good to see you. I might be here next week. I might not, but if
I'm
not,
not.
I'll be the
Well,
next.
okay.
We'll be in Chicago, so.
Well, that's fine.
Well, we had that planned before I knew I failed.
No. I would still go. You know, you need some fun.
Well,
Are you driving or?
Yeah, we're driving, but we have, Famous has an app.
So you can do
So I
questions.
can do my lectures and stuff on there. I'm like, you can do the actual lectures.
Yeah, you
on
can
there.
download them.
So, like I can do my lectures. I have my notebook that I can
Jot down notes.
Yeah.
Yeah, you'll be good. You'll be fine. You
Like,
deserve a
but-
weekend off. And the kids are coming. Are the kids now?
They're with us this week. We're headed over to Kings Island for a little bit because I've ignored them pretty hardcore this week.
That'll be fun though. They just did their new carnival thing or something.
That's what I've tried to explain, but people are still trying to guilt me into, well, you're not spending enough time. I'm like, do you not understand the gravity?
It's short term versus long term
Yeah,
here.
that's
Like,
well, like, Brian's like, well, you're not spending enough time with us. And I'm like, I work. I still cook, I still clean, I still do the dishes, I still do your laundry, I still do all of this, and I still do my bar prep stuff. Yeah, and then he's still trying to come at me like, you don't spend enough time with us. And I'm like, what else do you want me to do?
oh, that's alright.
Like, I just want so many hours a day. He knows what to expect. I just, yeah. Like, I worked too hard for this to like I was like, I'll pass this with or without you, so.
Whatever.
What up? Hey. This is just a boatload of fun.
I second your concern with independent beneficiaries and all that. So it's like, like, I get it in theory, but then you get a question and you're like, and that doesn't make any sense.
It made sense,
And then you get the
first
question,
question, I was
like,
like, great. It's the same with, in property, like the race notice.
I hate reading that form of the statute when they give you, because you get it when you study it, but then you get a problem and you're like, what? What is this language? I want to I almost wrote about it.
Yeah.